The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Two cases will be submitted this morning. Those cases are State of Iowa versus James Downey. The second case is State of Iowa versus Christopher McNeil. We'll begin by hearing the arguments in the Downey matter. Mr. Rehkemper.
Thank you, Your Honor. May it please the court? Had somebody told me that I would be arguing in front of the Iowa Supreme Court over the effect of using the word only in a sentence, I probably would have paid a little closer attention in English class. That being the case, myself as a product of the Hawaii Public Schools, I'm not going to pretend to be an expert on the English language. But even I understand that when you use only in a sentence or only in normal conversation, what you are doing is limiting, especially if you're following that with a list of statements. If I tell my son he can only have one cookie, I'm placing a limit on that. If the court tells me that I can only have 15 minutes for argument, that's not setting a floor. If a criminal statute specifically states that an application shall require only the applicant's name, the applicant's address, the applicant's driver's license number or non-driver's license identification number, and their date and place of birth, what that statute is doing is limiting what that application may require of the person submitting it. On January 14, 2015, the appellant James Downey went to the Johnson County Sheriff's Department and filled out an application to acquire a permit or permission to acquire a handgun under Iowa law. He truthfully provided his full name. He truthfully provided his address. He truthfully provided his identification card number, as well as his place and date of birth. He signed that statement. He signed the authorization allowing for a criminal background check to be run, a mental health history background check to be run, and none of the information he provided on that front side of the application was even alleged to be false.
Well, let me try this on this hypothetical. I understand your argument on only, so you could have a form that has the statutory requirements only, question, 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 and then has a provision that says the following are permissive. You may answer if you choose, and have some additional questions maybe.
Sure, if the sheriff wants to, what I would characterize the backside of the application as is in essence a cheat sheet for law enforcement to identify them to issues that may be arising or that they may want to look for.
My microphone. Yeah, if you choose to answer a permissive question, might you not make a material misstatement of fact?
You could if it's listed as being permissive and you elect to do it. On this particular application, at the bottom of the front page, it says, turn it over, there's questions you must answer on the back, and then it says the following must be answered.
All right, so is it your view that if it was permissive, the statute might have been violated, but since it was mandatory, it was not?
I don't think the statute would be violated under any condition because the statute specifically limits and says, here's what the application is. This particular statute that he was prosecuted on specifically says it has to be a false statement on the application or providing forged documentation in support of that application. And that's what got him into trouble was on the back side of the application. One of the questions asked, have you ever been convicted in any court of a felony or any other crime involving a firearm or explosive that could be punishable by more than 1 year? Mr. Downey had a prior conviction for OWI in the third offense, which is a Class D felony. Johnson County elected to prosecute him, even though after he was contacted by the sheriff, the captain of the sheriff's department, he cleared up that, no, I have a prior conviction for OWI third offense. And really this issue raises three general, or this appeal raises three general issues. Is One, as we've already talked about, is whether or not the questions on the back side of the application that are not articulated or required by the statute are in essence part of the application, so that a false answer to that would be a violation of 724.17. And then the following issue would be, even if you determine that those can be part of the application, is a untruthful answer to one of those questions on the back considered a false statement of material fact, given the fact that a sheriff still is required to administer a background check, and if the individual comes back as a convicted felon, you cannot obviously be issued a permit to acquire a handgun.
What about isn't there a certification on the application that I hereby attest that the information is correct?
It's on the front page, at the bottom of the front page after the statutory required information. That certification, first of all, it gives them, the sheriff, the permission to, it's a release for medical records for criminal history background check. And then it says that, correct, that it certifies that the information provided on this application is truthful and correct. And it stays with our argument, which is the application is that front side of State's Exhibit 1. The back side where they're asking those additional questions cannot be, as a matter of law, a part of the application under that code section. And when you look at the history of this code section and how it came about, or how it was amended back in 2010, 2011, that supports our argument even further. Because prior to it went into effect 2011, the legislature did a general overhaul of the permits to acquire, permit to carry, and what would be required of the applicant and what the sheriff's corresponding duties were with it. Prior to 2010, the code section simply required that the application state, and then it provided the address, place of birth, driver's license number, that kind of thing. In 2011, they specifically changed it to shall require only. The only reason to make that amendment that I can see is to limit what that application may require of the individual, to streamline the process so we're not having people fill out a 10-page bio in order to get an in order to be able to purchase a firearm.
What about the argument that this is not really part of the application, it's supporting documentation because it's on the back page?
If you look at the general structure of 724.17, I think that argument also fails, because it starts off saying that the Department of Public Safety is to create a form. Here's what the form shall require. And in addition, the next, I believe, couple sentences requires the individual to produce a license or an identification card and complying with the requirements. And then it goes on to state that a false statement of material fact is a Class D felony, but so is submission of forged or altered documentation. And I think when you look at it in a whole, the documentation is referring to the government-issued driver's license or identification card. I really don't see how you can read it to include assertions on the backside or in any type of questionnaire.
Why isn't let's assume your argument that the legislature never intended for those questions to be answered, but they were there and he didn't tell the truth. Why isn't that a false statement of material fact contained in the application?
Why is it not?
Right, I mean, just because the legislature may not require it was still in the application. Why isn't that a materially false statement?
It may be prosecuted under a different code section, but this particular code section limits it to the statements on the application itself or through the supporting documentation. And when it limits it, it's a criminal statute, it's inelastic, and it's resolved in favor of defendants. So to say that they can ask, I mean, what would be the limitation then on what a sheriff can require? The whole purpose.
My next question, what happens if they ask them the question, what color underwear are you wearing? And you put white instead of blue or blue instead of white, and can they prosecute them?
If you take the state's interpretation of the statute, that's something that's on the application. And that's why we're saying, when you look at how this all was changed in 2011, the idea was to bring everything together, to unify it, and to say, this is all we need, this is all, we don't need anything else. Otherwise, why not allow a sheriff to ask for an entire biography? Who was your middle school teacher? You know, any of those other things that,
If your client had left blank the backside and did not answer those extraneous questions, could the sheriff have denied the permit if he otherwise?
I think that there could be a challenge to the denial. I don't believe that there would be authority to deny it under the statute, but I think the practical application would be yes. And the other issue that comes up is those questions don't even ask if the individual's firearm rights have been restored. A person with mental health issues that has those rights taken away can apply to the court and get those rights restored, but that questionnaire on the back doesn't even address any of those issues.
Was the question that, was it arguably ambiguous as to, was he confused that his OWI third did not involve a firearm and maybe wasn't responsive?
I think it's more than arguably ambiguous. I think it is an ambiguous question, because when you look at the question in a whole, it asks, have you been convicted of a felony or any other offense involving a firearm or explosive? And as the professor from University of Iowa testified, she even read it to say, or to have the firearm or explosives as qualifying the felony. And if a professor at the University of Iowa was going to make that mistake, an individual who hasn't graduated from high school, who has an IQ of, 72, I believe it was, how do you fault him for not understanding that question?
That was a fact finding by the judge, and we'd have to find substantial evidence didn't support that finding, and.
Correct.
And would you agree there is sort of substantial evidence to support it?
That's why I'm not focusing my argument on that particular issue. It's an issue that I raised, and I think that if you ask an ambiguous question, I don't believe and I think the case law would support that a fundamentally ambiguous question shouldn't result in a conviction for fraud or this type.
A fundamentally ambiguous question may not be a misstatement of material fact if it's ambiguous.
Correct. Correct. And it also gets down, you know, whether or not the answer is a statement of or a false statement of material fact. How can a person's answer on the backside of the questionnaire be a material fact when the statute requires that the background check be conducted, and that background check is what dictates whether or not the application can be granted or not? If the sheriff doesn't have discretion to disregard a background check that comes back as a felon and says, well, you seem like a nice guy, you say you didn't have a felony, here's your application, go ahead and go buy a gun. If it can't have the ability to impact the decision-making process, as a matter of law, it shouldn't be considered a material fact.
Let me follow up on Justice Wiggins' earlier line of questioning. You know, the statute just says if you make a false statement on the application. It doesn't say if you make a false statement in response to a question that the state was allowed to ask you on the application. Now, if you take the analogy to like federal false statements, the general false statements 18 USC 1001, there in the elements of the crime, the Congress has said the government has to prove that the false statement was on a matter properly within the jurisdiction of the federal agency to which that you lied to. Here, the legislature didn't make that distinction. So why are we to make that distinction as to whether it was a proper application question or not? It was on the application whether it was proper of the sheriff to ask it or not.
It comes down to your definition of application. And what we're arguing is that the materiality is defined by the statute, and what the application consists of is defined by the statute, because the statute specifically articulates that the application shall only require the following things. And so our argument is that the application is defined in the statute, and the statute criminalizes a false statement of material fact on an application. So therefore, if it's not a false statement or not on to an answer, that is part of the application, it is a matter of law, cannot be a false statement under
What
this
about the language in the statute that says it's going to be on a form prescribed and published by the Commissioner of Public Safety? And obviously, this is a form that's created and published as part of the Iowa Administrative Code as as an application for this weapons permit, I guess I'll call it. And so how do you get around the fact that this is in fact the form that is prescribed, isn't it, by the Department of Public Safety?
Yes, and the form is wrong, and the form doesn't comply with the statute. I think you have to
It does
read.
comply with the statute to the extent that it provides for all that identification language, as you're calling it, but it also provides or asks questions of additional information. And I guess I'm having a little problem with the idea that while it says it shall only provide this identifying information, there's nothing in the statute that prohibits it from also asking additional information. Is there any prohibition in the statute?
I see my time is up. May I answer the question? When you look at the statute as a whole, yes, it says the Department of Public Safety shall create the form, and it shall be on the form. The form shall require, or the application shall require, only the following. So the statute limits it itself. And when you look at the change that took place in 2011, that took it from shall state to shall require only, that's a general indication that the legislature meant to limit what the application could entail. Thank you.
Thank you as well. Ms. Reinkoester.
May it please the court? There are three things that Mr. Rehkemper and I agree with about this case. The first is that Chapter 724 prohibits felons from acquiring a permit to acquire a weapon. The second is that the defendant is a felon. And the third is that Mr. Downey's answer to question number 2 on his application for this permit to acquire was false. What we disagree on is how we should read the application requirements in statute 724-17. And it's the state's position that you need to read this particular statute in pari materia with the requirements of Chapter 724 in general. And that's because in 724-15, the legislature outlines 3 categories of people who are prohibited from receiving a permit to acquire. And those people are anyone under the age of 21, anyone who is subject to 724-26, and anyone who is prohibited by federal law under 18 U.S.C. 922.
Yeah, but if we do look at the statute as a whole, we have the statute to acquire application, and we have the statute to carry a concealed weapon. The concealed weapon statute requires those questions on the back to be on the application, because it says require only and whatever in 2 other sections, and that's where those questions come from. And it appears that the legislature left that language out in 727-17, I guess. But the DOT, I always think of the DOT. The Department of Public Safety carried those questions over to the acquire statute, and not and that clearly were not in the statute. So if you look at the statutory intent, it seems to me that the better argument is that those questions weren't supposed to be on that application.
So defendant does make that argument in his reply brief, and that I believe the Latin phrase is the expressio unis est exclusion, which I took Latin in high school, and I don't know if I'm saying.
I don't need the Latin phrase. You just have to look, and if you start looking at the amendments over the years, it seems to bear it out if you go back to the beginning of time and see how each one was amended over the years.
Well, I think that that is a possible rule of statutory construction that you could use to determine the legislative intent in this case. But I think the thing to remember in a case like this is that the rules of statutory construction are not hard and fast rules. There are many rules that, as lawyers and the court uses to apply to determine
What about the rule that we should give effect to all the words of a statute? And doesn't the state's position read out or drop the word only?
I don't believe so, Your Honor, for the reasons that I stated in my brief, which is that, first of all, it's the state's position that the require only language is ambiguous, especially because the limiting modifier here, the only, comes after the verb, which is not grammatically correct. If it was grammatically correct, it would come before the verb. So, we have an ambiguous statute here. So we need to determine the intent of the legislature when they created when they decided to use the words, move it from state to require
So wouldn't
only.
a natural view of the intent of the legislature when they went from state to shall only state, or, isn't that an intent to narrow what's to be on the application?
I think it is. I think you're correct that it is an attempt to narrow what is on the application. But I think the use of those words in the 2010 overhaul of this statute needs to be put in context of the reasons why the overhaul happened in the first place. And this is something that defendant talks about in his brief. And this is also something that is, part of the common rapport of the statute, which is that, I'm sorry, I'm talking a little close, which is that, prior to this statutory overhaul, because the statute requires that each person apply for a permit in the county where they live. And prior to the statutory overhaul, county sheriffs were often asking questions that were not relevant to the aims of Chapter 724 in order to, exactly like Justice Wiggins says, well, what if someone asks you what the color of your underwear is? Well, clearly that is not at all relevant under the statute or the aims of 724.
The statute says the sheriff shall conduct a criminal history check. Maybe the legislature's purpose was to make the sheriff do the sheriff's homework and not to rely kind of, on something that was provided by the applicant.
I think it's both, because I think the background checks.
At the both part, it says only.
I get it from reading section 724.15, which specifically renders certain people ineligible from obtaining a permit to acquire, and not all of those disqualifying features can be discovered in a background check. The background check is mostly criminal history and mental health.
Wasn't the legislative intent, though, to take the discretion away from the sheriff? Because if you read the bill before then, sheriffs had the absolute discretion to deny someone a permit and a license to acquire. And the legislative intent was to take the discretion away from the sheriff, have an objective reason as to why someone gets a license to acquire or to carry a concealed weapon, and to make it easier for people to acquire and to carry guns. And in doing so, it makes sense that the only is a limitation on what they can do rather than an expansion of what they can do when you look at the whole legislative intent, because the whole purpose of that bill was to take the discretion away from the sheriffs, if you really look at the legislative history of it and follow the amendments.
And I don't think I disagree with that interpretation of the fact that it was meant to limit the discretion of the county sheriffs. But this application doesn't give county sheriffs any discretion. It doesn't allow them to deny an application for any reason other than the ones that are already listed in the statute.
But then my question goes, what happens if he put the wrong color of underwear on his questionnaire? Does he get prosecuted under this section?
Well, no, because that's not a material question. The materiality comes from 724.15, which specifically limits which people may be
But
permitted
it's
to acquire a handgun.
It's not material whether he committed a felony or not, because it's the sheriff's, the same argument can be made, it's the sheriff's obligation. I think Justice Mansfield was touching on it. It's the sheriff's obligation to see whether or not he had a felony. It's not the person who provides the information, at least under the acquire. Under the conceal, it is, but under the acquire, it's not required.
I would say that it's the sheriff's responsibility to run the background check. That doesn't necessarily mean that it's the sheriff's responsibility to uncover every circumstance or felony by which the defendant may be, or any individual may be ineligible to have a permit to acquire.
So, counsel, I'm not exactly clear as to what meaning you are giving to the word only in section 724.17. It strikes me that by giving the word material sort of a broad evidentiary kind of meaning, in 724.21, you are necessarily eliminating the word only from the application section. So what I'm curious about is what meaning do you give to only in the application statute?
Well, I agreed with the district court in this case that the word only modifies required in the sense of that's what sets the floor of what must be on the application, but doesn't prohibit what may be on the application, especially if the questions, as in this case, are relevant and only are relevant to whether or not you are permitted under the statute to be given a permit to acquire.
If somebody who was not a convicted felon left the questions blank on the backside, the questions that the Department of Public Safety said, here's the form to use, could the sheriff deny that application?
I'm not sure. It's possible that they could deny the application because they don't have the information necessary to determine whether the person is an eligible person under 724.15 in order to get the permit to acquire.
But they
And
are gonna find that out through the background checks, aren't they?
They'll find out whether perhaps, so it's important to remember that the background check may not necessarily reveal every disqualifying fact that may make someone ineligible to have a permit to acquire.
When you do an acquire, though, it's different than a conceal. Because when you do an acquire, you go through a federal background check. And there's a federal check through the FBI or some kind of federal agency up on that.
FBI.
So, I mean, you can see the legislature legislature requiring less information on the acquire before the person has the gun because of the federal background checks versus the conceal because they already have the gun. I mean, you can see the legislature making that distinction.
Well, first of all, under the concealed, you don't necessarily already have the gun because a concealed carry permit can be obtained instead of a permit to acquire. So you don't need the permit to acquire and then the permit to carry. So it isn't necessarily corollary. But I disagree with that assessment in the sense that if it were true that the only thing that mattered was the background check, we would not have Section 724.15 that otherwise limited people for being ineligible for permits to acquire.
Yeah, they're debating, I heard on the news yesterday, they were debating getting rid of that section as part of their firearm overhaul because they think it's silly. I don't know where they're going to end up.
Well, and I don't know where they're going to end up either, but I think that debate maybe lends credence here in the sense that those requirements are currently in place. And if you look at the whole Chapter 724, when it was rehauled in 2010, the 724.15 was also changed. It used to be a much broader statute prohibiting a much broader group of people from obtaining a permit to acquire. And the legislature limited that to just the three categories that are left. And the fact that they left three categories of people show that it was important to them that these people not be permitted to get a permit to acquire. And the thought that you
Can I interrupt you one more time? This application was done on 10/29/10 after the legislation was passed. Do you know what the application said prior to the 2010 legislation?
I don't, Your Honor. I looked and I couldn't find it myself. So I don't have an answer to that. But, I think it's what Justice Zager was saying earlier, which is that it is interesting that there are no limiting words in this statute in terms of not asking about the otherwise impermissible or the otherwise ineligible circumstances which would render someone unable to get a permit to acquire. There's nothing in the statute that forbids DPS from asking about the eligibility of someone under the statute. And that's really what I want to emphasize is that these are all relevant questions under the statute. Everything here is material to whether you are permitted to obtain a permit to acquire. They are all questions that are under 724.15, which is legislature specifically outlined as the group of people who are unable to receive a permit to acquire. Are there any other questions? If there are no other questions, the state would ask that you affirm Mr. Downey's conviction. Thank you.
Thank you as well, counsel. Rebuttal?
If you take the state's argument to its logical extreme, there are simply no limitations on what a sheriff can ask a person in the application. There may be limitations to what may be considered material for criminal prosecution, but not to what can be requested.
Let me take their position not to an extreme, but a little bit beyond where you would go, maybe. All right. So, suppose the application here was just limited to the first page, which you wouldn't have a problem with. And then, am I right?
Correct.
All right. Then the sheriff writes back to Mr. Downey and says, you know, I have a question, by the way. Have you been convicted of a felony? And Mr. Downey writes back and says, no. Could he be convicted of making of violating 724-17, making a false statement in documentation submitted with the application?
No, because documentation as used in this statute is referencing the government-issued identifications, in my opinion, in looking at this, at the statute in its total.
But
He
it
could
just
be-
says any materially falsified documentation in connection with such an application.
But if you look at the flow of the statute, it says, here's what the application shall only require. Here's also what the individual is required to submit as documentation along with it. And so my reading of the statute, when they're talking about documentation, they're talking about, you know, a government, official documents relied upon as a basis of proof or support of a statement. There may be other offenses that he would have committed in that circumstance. False statement to a police officer would be one of them that they could prosecute on, but it wouldn't rise to the same level as a Class D felony. I mean, here, you also got to remember that the application, as the individual is told on the application, is considered a public record. So what would prevent a sheriff from asking people their religious beliefs, their sexual orientation?
It's gotta be, listen, no one, I think, is gonna say that underwear or religious beliefs is gonna qualify, but,
What would prohibit it, though?
well, it's got to be germane to the application. Now, I think that's right. Now, suppose this, though, suppose the front side of the form was filled out and there was no backside.
Correct.
And the sheriff does his work and finds out there's a conviction. And the sheriff then calls up the guy and says, you know, I did the background check and I find you've been convicted of a felony. Is this a wrong name problem? I mean, is this you? I mean, I'm gonna unless you've got an explanation, I'm gonna deny the permit. And the guy then says, that's not me, that's somebody else. I was never in Iowa during that, all false. Well, is that a false statement in connection with an application?
No, because it may be in connection with the application, but not on the application. And when you look at the words of the statute, that's what I'm saying. Nothing necessarily prohibits other prosecutions for other offenses that may fit the facts of the case. And also in this case, we have Mr. Downey stating when he's called and asked about his prior criminal history, yeah, I did the Hope House or whatever it was. I have the OWI third offense. This isn't something that the guy tried to hide when he was actually asked it in a non-compound question in a way that person of his education and background could sufficiently understand. And that's one of the points of requiring clear questions. And it's also one of the points of requiring a false statement of material fact. And when the sheriff is required to do the background check and then approve or deny based upon that background check, the rest of it is just a cheat sheet that they can use for whatever reason, but it's not part of the application, and it can't be a statement on the application because the application is limited by the terms of the statute. Any other questions?
You know, at the end of the 724-17, it says that a person who makes what the person knows to be a false statement of material fact, that describes the crime. Why would the legislature put in their material fact if the application needs to be confined to the statutory requirements anyway?
Because it's on an application, so in essence, it's saying if you're given the false name or the wrong name, something to that effect.
Well, aren't you saying that everything in that application is required and that it would necessarily be material anyway if it's required?
I don't know that necessarily the city or state, I mean, if you say Urbandale instead of West Des Moines, I don't know that that would necessarily be a material fact, even if the statute requires that information. And I think they were just going above and beyond to be clear that we wanted to actually have some type of impact or implication on the background check process, would be my interpretation.
Thank you. The case of State versus Downey is now then submitted. We'll next hear the arguments in State versus McNeil.